morning, WTOB listeners. This is For the Record with Greenwood Law. I'm Dylan Greenwood here with Harold Eustache. Appreciate y'all joining us this morning here on WTOB. Before we get started, we want to do a quick public service announcement for everybody out there. If you or someone you know or care about has a court date, anywhere from a speeding ticket all the way up to something more, because anything and everything goes on. But if that's coming up, we just want to let everybody know that courts are starting to get in session more. Forsyth County has a clear plan to get back to having more cases in court. But it is always up to change. And so we recommend people check on the Forsyth County Clerk's website. And if you got anything else in another county or one of our surrounding counties like Guilford, Davie, Davidson, Stokes, Surrey, Yadkin, wherever, we recommend that you check on the North Carolina Courts website. And if it gets down to it, you're always recommended to call the clerk of court for that county. But more and more courts are up and running. We have a new Chief Justice of the Supreme Court here in North Carolina. He modified some of the COVID-related orders and left it up to each individual county as to what they might do, and each one of them has taken a different approach. So just be mindful of that going forward, and we just want to let all of our listeners know. But today's program is kind of keeping along the same track of running through your constitutional rights that are afforded to you through the Bill of Rights. We've started a couple of weeks back, we did First Amendment, just what that meant for people. Then last week we took on Miranda, which has heavy context within the Fifth and the Sixth Amendment, your right to remain silent, your right to an attorney. And today we're going to back up to the Fourth Amendment, which concerns searches and seizures. And this is a common interaction that people have with law enforcement, especially during traffic stops. Isn't that right, Harold?
That's right. Most of us interact with a Fourth Amendment issue with traffic stops, and most of us interact with officers during a traffic stop. And so there becomes a Fourth Amendment issue when a person is stopped. The Fourth Amendment deals with what's called unreasonable searches and seizures. It essentially prohibits those types of searches and seizures without a warrant, unless there is a warrant or probable cause to search. And that's what the Constitution says. And that sounds simple, but of course the courts over the course of many years have delved into each and every bit of these different caveats that we have that deal with searches and seizures. So typically, the most simple thing we see is somebody is stopped by a law enforcement officer. That law enforcement officer comes up, and let's say they don't have probable cause to necessarily search, but a lot of times a law enforcement officer will just ask, hey, do you have anything in your vehicle?
Not that I'm aware of.
That could be compromising. Not that I'm aware of. No, I don't have anything in my vehicle. Well, hey, would it be all right if I search?
Yeah,
and that's what a law enforcement officer
ahead,
asks. And once you give that consent to search, you're essentially, nullifying your Fourth Amendment right to make that officer get a warrant or have probable cause because you're giving consent. Mm-hmm. And at that point, that officer is going to search. So if you back up before that and you're asked by that law enforcement officer, hey, is it okay if I search? You have the option to not give consent. And that's where, when you don't give consent, that's where these other factors sort of kick off.
But Harold, if I don't give consent during that search, that makes me look guilty, right?
Wrong. I mean, it doesn't, a lot of people think about in the moment, when it's one-on-one with another person, whether or not they look guilty. And ultimately what's going to matter for them is what happens in court later. And it is extremely important for all of our listeners to understand that not only should you never give consent, you're certainly not helping your case in any way by giving consent. I can't think of any case really, especially in a traffic stop scenario, where a person is helping themselves by giving consent to search. It just isn't a thing that would help you.
Oh gosh, I know. I don't know how many times over the years I've gotten a call from some potential client or something that's going on, and they say, they start going through their interaction with the officer, and they say, well, I let him search. That was the right thing to do, wasn't it, Mr. Greenwood? And I go, no, it really wasn't. You did. They're like, but no, I helped my case. I was compliant. I was nice to the officer. I was cooperative. But they still, I didn't think that they would find anything, but they actually end up finding, a lot of drugs or something like that. And you're kind of sitting on the other end going, golly, why? If you knew that was in there, why would you let them do that? And it comes down to people think that by cooperating in that is a form of cooperation by doing that. And they think that basically by letting it happen, they're doing the right thing, and therefore they're going to get rewarded for it. And maybe there are either no charges or lesser charges because they said that, someone could search.
And it doesn't work that way.
Oh gosh, rarely does it ever. In fact, most of the time it just doesn't.
The standard for the Fourth Amendment is essentially that any search by law enforcement must have a warrant. I mean, just think of it that way and work backward from there. And that's how people should think of their own rights, that the government doesn't have the ability to intrude on you unless they have a warrant. And of course, there are all these different circumstances where warrants aren't necessarily applicable, but people should work back from that when they think about their own rights, their own Fourth Amendment rights. One of the ways that an officer can search is with probable cause. So can you explain how that would work?
Correct. So, as you were getting at, warrants are typically required. And in fact, a search is presumed unreasonable if there isn't a warrant present. But to even get a warrant, you have to have a finding of probable cause. And in fact, the United States Constitution specifies that in order to support that finding of probable cause, there have to be sworn statements to justify it. It can't just be somebody running down to a magistrate or judge and saying whatever. They've got to put their hand down on a Bible and either swear under oath or affirm that the statements that they have given are true and correct and accurate to the best of their knowledge. But there are times when that probable cause can be established on the spot in a traffic stop without the need for a search warrant. And in fact, the door is open for that more in the context of a traffic stop than almost any other interaction you would have with law enforcement. The reason why is that the Supreme Court, we start off by saying, we've got the standard, you need a warrant, and then you're working back from there. Well, we're about to pull back. And the pullback that you have here is that the Supreme Court said that in your car, you have a reduced expectation of privacy because of the nature of the car itself. Think about a car. You're driving along, some are 2 doors, some are 4 doors, some are more doors, and you've got windows all around, and it should be windows that you can see through, or else you might have a window tint violation. And because of that, you can see almost everything in the cabin of the car. And there's a reduced expectation there. Even the stuff in your car is more easy to access and open up. Think of all the things in your car that don't have locks on them. There's more things that do have locks on them than don't. Your glove compartment has a lock on it. Your trunk usually has a lock on it. That's about it. There are very few center consoles or anything like that have a lock associated with them. And so because of that, those containers, as they're dubbed in the context of a search warrant or the Fourth Amendment, are more easily accessed by law enforcement officers when it comes to the context of traffic-related searches. And in fact, it really has opened the door quite a bit because they said that there's a reduced expectation of privacy, especially as it relates to someone's home, where the law really carves out and protects people and their privacy in their home. And so that is a drastic difference from being out there on the road and in a car where you can see everything that's going on in it.
No, that's one of those things. I remember when I was in law school, I thought, your car, your home, those are kind of sacred things that we think have the same sort of expectation of privacy. And of course, as you just said, there is a diminished expectation of privacy in a vehicle, and that's really important because most of the interactions with law enforcement involve vehicles instead of homes. So when an officer does have probable cause to search a vehicle, that they don't need a warrant. And a lot of times that probable cause, in most of our situations, to search comes from smell.
It has been.
Yeah.
But we've addressed that.
We've addressed that.
At least in the context of marijuana,
right.
That may not be valid anymore. We did that on a previous episode.
But that's where officers are believing there's this probable cause to search. And so that's how a lot of searches get initiated.
Other ways would be like plain view. Let's say that there was a baggie of drugs in plain view, just in the cup holder. I've heard that a lot. Or an open container of alcohol. That's probable cause potentially to search, because it's basically you're trying to a law enforcement officer is trying to assess, was it more probable than not that some sort of criminal activity is afoot? And based off of that assessment, if they see something that's pretty much evidence of the crime happening, they've just certainly met that standard, potentially a probable cause. And so that's where that analysis can come into play. Another,
outside of your vehicle and home, another place that has an expectation of privacy is your body itself. And there's plenty of context, especially in DWI cases, where an officer needs to take blood or some sort of sample from your body. In order to do that, without consent, an officer would need a warrant to do that in order to get blood from you. So your actual physical body, in order for law enforcement to intrude your body, that would require a search, and that is a Fourth Amendment issue that I think sometimes people don't think about.
Yeah, no, you're exactly right. But when it comes to a traffic stop, there are like 6 sort of exceptions, if you will, that are most relevant when it comes to traffic stops for that warrant requirement. And the first 2 don't require any form of probable cause. And that is a consent. So you just said, hey, yeah, search my car. That's fine. Which, I mean, I would never do that. I know for a fact there is nothing in my car that will ever get me in trouble at all. But I would never give consent for someone to search my car. I have seen too many things over the years that would freak me out for me to justify that happening. I just wouldn't do it. The other way is for a frisk. A frisk does not require a showing of probable cause. Frisks happen to your person, your body, and they can also happen to your car. And the justification for a frisk, which is a light form of searching, it's not a full-on ransack the car kind of search. It's more so for officer safety.
Right.
And there has to be actual showings that there is some sort of suspicious criminal activity, that there is a reasonable belief that the frisk is needed for the safety of the officer, and the search is only done for the parts of the car or the person that someone could access in a way that could compromise the officer's safety. So a frisk couldn't be, if you're the driver, it's probably not going to be for the trunk. That couldn't happen. But a frisk might be for the areas between the seats, the center console, the area underneath the seat. That might be justifiable for a frisk. And then there are some other exceptions to the warrant requirement that do have require a showing for probable cause. And there's just the automobile exception, there's the plain view doctrine, there are exigent circumstances, and then there are searches that are incident to lawful arrests. So let's run down through some of those, Harold.
Yeah, we've kind of touched on the automobile exception and plain view doctrine, but another important one is exigent circumstances, and essentially those are circumstances that preclude an officer from getting a warrant because of timing or safety or other emergency issues. So, for example, if an officer is in hot pursuit of someone, of a suspect, and they don't have time to necessarily get a warrant, that could be an exigent circumstance that would preclude the officer from a search warrant. Or if there was a reasonable belief that evidence was going to be destroyed, for example, drugs were going to be flushed down a toilet, a classic example, that may be a reason for an officer to enter a home or enter a vehicle or whatever without a warrant. So just think of exigent circumstances as these emergency circumstances that happen in order for an officer to search without having to get a warrant, but would still have to have probable cause to do that.
Yeah, and that's exactly right. You have to have that probable cause, and then you have to have the showing that the exigent circumstance was present and actually reasonable.
Mm-hmm.
It was a reasonable belief that was occurring. And you are right. Most of the time it involves officer safety. It involves destruction of evidence.
Mm-hmm.
And so in a traffic context, this most commonly comes up with warrantless blood draws.
Mm-hmm.
As a justification to do a search without a warrant, because especially if that person is intoxicated, just think about how your body works. You drink, as you drink more and more, your BAC rises. Okay, you stop drinking, your BAC goes down. Well, as you stop drinking, it goes down more and more and more at almost a set rate based off how you metabolize alcohol. And that is based off of weight, how much you drink, your gender, whatever it may be. Those all affect, and if you're on any medications, those all affect your metabolic rate. And so if you stop drinking, which usually when you're having an interaction with a police officer, you're not drinking.
Mm-hmm.
So then from the moment you have that interaction, your BAC is always going down. And so there's an exigency there to preserve evidence as a justification for potentially a warrantless blood draw, which is an invasion of your body, which normally does require a warrant, like we said earlier. But exigent circumstances are something that really run the gamut. It doesn't have to be just for officer safety. It could also be for the safety of the public, for other people. Some sort of basically unique justification for the search that makes sense that your Fourth Amendment right would be compromised. And so there are a few different ones out there that would justify it. But again, you still have to have that probable cause that some sort of criminal activity was going on.
And the last exception for a warrant is a search incident to arrest. And these happen obviously a lot. When a person is arrested, a lot of times an officer will search, especially that person to start off with, for officer safety reasons. So a person is put in cuffs, officer puts them under formal arrest, and will search their pockets, search to see if they have any weapons or anything on them that could harm that officer. But sometimes in searches incident to arrest, an officer will also search parts of a vehicle, but there are different caveats to that. If you want to explain that.
Yeah, absolutely. So when you're doing a search incident to arrest, first and foremost, it has to be a search incident to a lawful arrest.
Right.
And sometimes that is for the alleged criminal activity that is going on concurrently with the search. So what I mean by that is let's say you've been alleged to have committed some sort of criminal act right then and there. You get arrested, and then incident to that arrest, you get searched or your car gets searched. Another way this happens is if you've alleged to have done something in the past, there's a warrant out there, and then all of a sudden, you get pulled over and they run your information, and then all of a sudden they go, well, you've got an arrest warrant out there, we're taking you in. And pursuant to that search warrant, pursuant to that arrest warrant, they search you. So those are two ways that can happen. Those are the two most common ways. But when you're looking at the search incident to arrest, like I said, it has to be to a lawful arrest. So if the arrest that occurred did not have probable cause to support it in any way, then it would potentially invalidate the search. So that's one of the things that we look at on something like that, where you go, well, was the probable cause for whatever they were arrested for, was that present in the first place? If it wasn't, then you didn't have the right to trample on someone's Fourth Amendment rights and search at that point.
And these searches incident to arrest, it's important. There's a scope of what can be searched. So if somebody's arrested right next to next to their vehicle, next to their car, their front door, the officer can search around the cabin of that vehicle a bit, just to make sure that there's no safety issue. But the officer can't necessarily search the trunk of the vehicle at that point, because it's too far removed from the actual arrestee in order to justify that officer has the ability to search that trunk without a warrant. So there are limits to what an officer can search when it comes a search incident to arrest, and sometimes that's important in our cases because if an officer does go beyond what that limit is, and let's say they find some illegal substance, then it may be put the possession of that illegal substance or that illegal substance itself may not come into court because the search went too far out of the parameters of it, where it should be.
If you're just joining us here on WTOB, I'm Dylan Greenwood. This is Harold Eustache, for the record with Greenwood Law, and we are talking about your Fourth Amendment rights against unreasonable searches and seizures. And the most common way that occurs is through the context with traffic stops. And we've been talking about how sometimes in the midst of a traffic stop, people are searched incident to an arrest. And as Harold was talking about, there are issues with just how far those searches can go. And one of those things comes down to a case called Arizona v. Gant. It basically says if you're removed from a car, you're arrested, basically exigency, those needs for officer safety, those needs to preserve evidence, basically you've taken care of a lot of that through the arrest itself. When you've removed that person from the car in that way, you've removed the exigency. So when you do that, you've removed the hook to search someone's car instant to a lawful arrest, and all of a sudden you probably will need a warrant at that point. So that's kind of a unique little thing, and that's what we were talking about in the beginning, how yes, the Fourth Amendment, some Supreme Court cases, earlier in history, they set out this thing that said, well, basically it's unreasonable if you don't have a warrant. And then there's been all of these cases that have pulled that back in and created all these little bitty exceptions and all of that. And that's why, these cases are so technical, and it's important to have an attorney. Well, Harold, people ask us all the time, okay, you guys are attorneys, you deal with this stuff day in and day out. How should I interact with law enforcement? So let's say, I was pulling you over, you were speeding going through downtown Winston. I know how you do, man. Mm-hmm. I know. I see you. You kick that thing into sport mode and you let it loose.
Is that you or me?
No comment. But I pull you over and I say, license and registration. Yep. You hand them over. I go, hey, you got anything here? You mind if I search? What would be the appropriate response?
So politely, you need to tell the officer that you are going to exert your Fourth Amendment rights, and you are not going to consent to any search, but you're going to say, of course, again, politely, you're going to tell the officer that if an officer does have a warrant present with him, that you will comply to that. Or if the officer is going to go get a warrant, you would also comply to that, but you wouldn't be consenting to any search at that time.
Mm-hmm. And I think that's a great way to handle it. It's also a good idea to not give any kind of affirmative yes or no. You don't have to answer their questions. The reason why is because you have a Fifth Amendment right not to make statements against your interests. But let's say a law enforcement officer doesn't heed what you say, and all of a sudden they're just searching. How should you act?
If it's at that point, you've said what we just told you, and the officer says, well, I disagree and there's probable cause, I'm going to search anyway. At that point, you let that search happen. You back up. You don't interfere with that officer. You don't try to yell at the officer or do anything like that. You let the search happen, and that you let that fight happen in court. You hire an attorney or have an attorney appointed to you, and you deal with it in court. You don't deal with it there. You've already exerted you haven't given consent. That will be important for your case later, and you go from there.
Listeners, thank you for joining us here this morning on WTOB on For the Record with Greenwood Law. We've had a great time discussing Fourth Amendment. It's something I've been particularly passionate about throughout my legal career. It's a fascinating part of the law, really, but as you can see, it's a very technical one. But that being said, next week we are going to switch gears entirely. There's a case that came out, a Court of Appeals case that came out that involved a very unique case involving adoption. And it was a very heart-wrenching case that happened here in North Carolina, where there was an alleged fraudulent adoption, and basically the adoption got undone and all this stuff happened. So Jessica Armentrout, family law attorney here at Greenwood Law, we're going to sit down and go through that case, talk about the different parts of adoption and how that works here in North Carolina. But before we go, Harold, give them that Greenwood Law Bill of Rights.
So first, I will not represent myself in a court of law. Second, I will not do law enforcement's job for them. Third, I will not make statements when stopped by law enforcement. That's your Fifth Amendment right. Fourth, I will not consent to searches when asked by law enforcement. Again, your Fourth Amendment right. And I will not be my own star witness for the prosecution. Remember, folks, it's important to know your rights, to stay safe. This is For the Record with Greenwood Law, signing off.